Lockout in Industrial Disputes Act, 1947. Meaning of lockout. The Industrial Disputes Act, 1947, IDA, defines lockout under Section 2(l) as the temporary closing of a place of employment, or the suspension of work, or the refusal by an employer to continue to employ any number of persons employed by him. Lockout as a tool for industrial disputes. Just as a strike is a weapon used by employees to enforce their demands, a lockout is a tool available to employers to pressure employees to accept their terms during an industrial dispute. It serves as a countermeasure to strikes and aims to achieve the following. Compel employees to negotiate. By halting production and wages, a lockout can force employees to reconsider their demands and return to the negotiation table. Demonstrate employers' strength. A lockout can show employees that the employer is willing to endure temporary losses to protect their interests, potentially weakening the employee's bargaining position. Maintain control. By taking back control of the workplace and production, employers can try to regain control of the situation and discourage further industrial action. Restrictions on lockouts. The IDA restricts the use of lockouts in certain situations. During conciliation proceedings, once conciliation proceedings have begun to resolve the industrial dispute, employers cannot declare a lockout. Without prior notice, employers must provide at least 14 days written notice to the government and employees before declaring a lockout. In essential services, lockouts are prohibited in essential services like railways, electricity, and water supply. When deemed illegal, lockouts declared in violation of the IDA's provisions, such as during conciliation or without proper notice, are considered illegal and can be challenged by employees. Consequences of illegal lockouts. If a lockout is declared illegally, the employer may face the following consequences. Payment of wages to employees. The employer may be required to pay wages to the affected employees for the lockout period. Reinstatement of employees. The employer may be directed to reinstate the locked out employees. Penalties. The employer may be liable to pay fines or penalties imposed by the government. Alternatives to lockouts. Before resorting to a lockout, employers should explore alternative methods of resolving the dispute, such as negotiation, engaging in good faith negotiations with employee representatives to reach a mutually acceptable settlement. Mediation, seeking the assistance of a neutral third party to facilitate communication and dialogue between the parties. Conciliation, utilizing the services of government conciliation officers to help resolve the dispute. Conclusion. Lockout is a powerful tool in industrial disputes, but it should be used with caution and only in accordance with the law. Employers should consider alternative methods for resolving disputes before resorting to lockouts.
Note, this is a brief overview of the Industrial Disputes Act, 1947. The Act is a complex piece of legislation, and it is recommended that you consult with a legal professional for any specific advice or interpretation. Thanks for joining this live session on Facebook and YouTube at Vinay Shukla. Notes and exercises are available on https://yovinashukla.in. Thanks once again to all of you.